Your daily routine is basically a crime spree. You just have the good fortune of living in the right century. The simple act of living, singing, eating, wearing the wrong shoes, was, at various points in time, enough to make you a public enemy. We're about to show you a world where singing in the shower, owning too many potatoes, or playing pinball could get you arrested. These aren't just obscure rules from dusty books. This is a comprehensive catalog of history at its most bafflingly, magnificently idiotic. Number 1. The Ballad of the Bathtub Bandit. Imagine yourself in 19th century Pennsylvania, unwinding in a hot bath. The steam is rising, you're feeling relaxed, maybe a little joyful, so you start singing your favorite tune, perhaps an aria or a simple folk melody. Suddenly, a constable is at your door, badge glinting, face severe. Why? Because an obscure but genuine old municipal law actually made it illegal to sing in the bathtub. The crime? Unlicensed solo acoustic performance in a sealed bathroom. The logic of idiocy. This wasn't a noble effort to protect the public from terrible singers. The official, recorded reasoning was a masterpiece of hyper-speculation. The sound might startle horses on the street outside. Think about the chain of events someone had to imagine to write this law into existence. It required a lawmaker to believe. A man sings a baritone solo in a tiled room, amplifying the sound. The sound successfully penetrates the glass, wood, and brick structure of the house. A horse, 2 blocks away, is so finely attuned to the frequencies of a man singing an opera in a basin of water that it instantly panics. The panic causes a catastrophic carriage pileup, resulting in public injury and property damage. It's a level of cause and effect reasoning that is both utterly insane and magnificent in its bureaucratic paranoia. The law implies the existence of a special division of law enforcement, the Bathroom Acoustics Division, dedicated to monitoring the sonic output of domestic ablutions. This ordinance stands as a testament to the fact that at one point in time, the perceived fragility of a horse's nervous system outweighed an individual's right to joyous vocal expression. The true crime wasn't the singing, it was the catastrophic overestimation of equine sensitivity. Number 2. The Samoan birthday felony. In most parts of the world, forgetting your wife's birthday gets you the silent treatment, a frosty dinner, or a night exiled to the sofa. It's a domestic oversight, a personal relationship failure. But in the modern-day island nation of Samoa, that oversight can get you a court summons. The crime? Criminal memory lapse, failure to acknowledge the annual spousal anniversary. The logic of idiocy: it is genuinely, legally, and enforceably against the law for a husband to forget his wife's special day. If a wife, tired of predictable apology flowers, chooses to report this transgression, her husband can be officially questioned, warned, and even fined by the authorities. This is not some forgotten ancient ceremonial text. This is a contemporary attempt to literally legislate thoughtfulness and emotional attentiveness. You have to admire the sheer ambition of a government body deciding that marital felicity is a matter of state security. It transforms a simple domestic oversight, a honey-do list item, into a prosecutable offense. This system places the state squarely in the role of the ultimate marriage counselor, ready to apply the full force of the law to a personal slight. One can only imagine the specific courtroom drama. Your Honor, the defendant claimed his phone calendar mysteriously deleted the reminder. The prosecution arrests. The defense counters. But, Your Honor, the pressure of remembering his tax filing date caused a temporary stress-induced memory failure that only affects non-fiscal deadlines. The existence of this law suggests a perfect, terrifying societal structure, where emotional intelligence is mandatory and the local police station doubles as a repository for forgotten anniversaries. Number 3. Pinball, the mechanical menace of New York City. Today, pinball is a nostalgic arcade classic, a cherished piece of Americana, celebrated for its mix of physics and dexterity. But from the 1940s all the way to 1976, it was public enemy number one in New York City. The crime? Possession and operation of an insidious, skill-deteriorating, mechanical gambling device. The logic of idiocy? Mayor Fiorello LaGuardia waged a personal, almost fanatical war against these machines. He saw them not as games of skill, but as insidious gambling devices controlled by the mafia, designed to corrupt the city's youth and drain their lunch money, thereby funding organized crime. LaGuardia famously led theatrical raids, personally smashing confiscated pinball machines with a sledgehammer for press photographers, a moment of performative, anti-vice brutality. The core stupidity of the ban lay in its refusal to acknowledge pinball as a game of skill. The law insisted it was purely based on chance, thereby categorizing it as illegal gambling. For 3 decades, pinball was driven underground, treated with the same severity as illegal liquor or drug trafficking. The ban was only lifted after a pinball wizard and magazine editor named Roger Sharpe staged a legendary courtroom performance. Sharpe, under oath and before the council, proved the game was based on skill by calling a specific complex shot, a flipper move and ramp combination, and then flawlessly making it, stunning the council into submission. His shot literally flipped the law. The crime was never the game itself, it was the government's inability to distinguish physics from chance. Number 4. The Vagrancy Act. Ghosts and Greed. In 19th century Britain, your choice of Halloween costume, or simply your talent for spectral impersonation, could have led to your arrest. The Vagrancy Act of 1824 was a broad, powerful piece of legislation targeting fortune-tellers, con artists, and anyone using subtle craft to deceive the public. The crime? Attempting to mislead or deceive the public while impersonating a deceased entity. The logic of idiocy. This was the notorious era of spiritualism and seances, where fake mediums would stage elaborate hauntings to swindle grieving families out of their money. The law was designed to stop sophisticated fraudsters, often with harsh penalties. But the incredibly vague, wonderfully broad wording of the statute made it illegal for anyone to pretend or profess to tell fortunes or use any subtle craft, means, or device, by palmistry or otherwise, to deceive and impose on any of His Majesty's subjects. More absurdly, it was interpreted as making it explicitly illegal to pretend to be a ghost, spirit, or other supernatural being. This created a hilarious legal gray area. Was the crime the sophisticated use of mirrors and smoke to fake a seance? Or was it the simple, innocent act of a child with a bedsheet over their head saying, "Woo"? The law essentially criminalized professional spectral impersonation, creating a legal definition for spooky fraud. It meant that the police technically had the authority to arrest anyone whose spooky antics were just a little too convincing. The crime was pretending to be dead for profit, or perhaps just for fun. Number 5. New York's 8 a.m. flap ban. In old New York City, cleanliness was next to godliness, but it operated on a very strict, unforgiving timetable. The crime, shaking dust, lint, and debris onto the heads of pedestrians after the start of the business day. The logic of idiocy. A city ordinance once officially made it illegal to shake out your rugs, carpets, or mats from a window after 8 a.m. If you wanted to share your apartment's accumulated dust and debris with the world below, you had to be an early riser. Sloth was no excuse. This was a profoundly practical, yet absurdly specific attempt to prevent pedestrians from getting an unwelcome shower of grime on their way to work or to school. It paints an incredible, comical picture of a daily urban ritual. At 7:59 a.m., the city would be filled with a frantic, citywide symphony of rug flapping,
a frantic, communal act of cleaning followed by an abrupt, coordinated silence the moment the clock struck 8. The law established a literal cleanliness deadline. It was a race against time where the prize was a clean floor and the penalty was living in filth until the next morning, or worse, facing a citation for littering by air. This ordinance perfectly encapsulates the clash between private domestic needs and the public requirement for urban order, where the government had to legislate the timing of dust removal to protect the dignity of the morning commute. Number 6. The New Jersey Noodle Noise Ban. New Jersey has a reputation for some interesting local quirks, but one of its cities took things to a new level by legislating table manners. The crime? Creating an excessive, audible sound while consuming liquid or semi-liquid food. The logic of idiocy. A local ordinance once officially made it illegal to slurp your soup in public. You have to respect the sheer, beautiful audacity of a government body deciding that while issues like organized crime, tax collection, and failing infrastructure are present, the real threat to civil society is the noise someone makes while enjoying a simple bowl of tomato soup. This law transforms every diner into a potential crime scene and every soup spoon into a piece of evidence. Imagine undercover officers, the decibel detectives, sitting in a bustling restaurant, listening intently for the telltale sound of schlurp, ready to spring into action and issue a citation. While it was likely never enforced with jail time, the fact that a group of legislators sat down, debated, and actually passed this into law is a beautiful, magnificent testament to humanity's ability to focus its legislative power on what truly matters: polite consumption. The law proves that in one New Jersey town, a politician decided that good manners were too important to be left up to mothers.
Number 7. North Carolina's Pitch Police. If you've ever been told you can't carry a tune in a bucket, you would have been a wanted criminal in one particular North Carolina town. The crime? Publicly or privately producing vocal sound that is not aligned with the correct musical scale. The logic of idiocy. An old city law made it explicitly illegal to sing out of tune. This wasn't about professional public performances or disturbing the peace. The law, as written, applied to singing in general. It's a law that is both hilarious and existentially terrifying. How on earth would it be enforced? Would they have a pitch police squad roaming the streets with tuning forks, ready to issue citations for flat notes or horrifyingly sharp key changes? Imagine the courtroom scene. The prosecution presents Exhibit A, a professional music teacher who was forced to listen to the defendant's horrifyingly sharp rendition of a popular folk song. The defense argues for temporary insanity induced by a sudden shift in atmospheric pressure affecting the defendant's vocal cords. This law represents a utopian and, frankly, terrifying vision of a world where musical mediocrity is not just frowned upon, but actively prosecuted. It transforms the act of singing into a high-stakes, technically demanding public performance, demanding perfect pitch from everyone, from the opera star to the shower crooner. Number 8. France, the railway kiss ban. France is celebrated as the world's capital of romance, which makes this particular law a masterpiece of irony and bureaucratic frustration. The crime: excessive, schedule-disrupting public displays of affection at transportation hubs. The logic of idiocy. In the early 20th century, it was forbidden to kiss on train platforms. This wasn't a moral crusade against public displays of affection. It was a desperate, panicked measure by the National Railway authorities to maintain the national train schedule. Apparently, couples were engaging in such long, passionate, cinematic farewells, complete with tears, dramatic embraces, and last-minute whispering, that they were regularly causing significant delays. People were missing their train and then blocking the doors, leading to cascading delays across the entire rail network.
The railway authorities were forced to choose between love and on-time performance and efficiency. They chose efficiency. It is the most wonderfully, gloriously French problem imaginable. The country's transportation infrastructure was being brought to its knees by the sheer, unbridled power of romance. Conductors and station managers had to become love police, breaking up passionate embraces to ensure the TGV or its equivalent could depart as scheduled. The law proves that when the French state has to choose between love and its timetable, the timetable wins. Number 9. Peter the Great's beard tax. In the late 17th century, Tsar Peter the Great of Russia embarked on a desperate, massive mission to modernize his country and drag it kicking and screaming into the Western European world. His first major target was not military reform or industrialization, it was facial hair. The crime, possessing unauthorized traditional facial hair without proper state licensing. The logic of idiocy. Peter saw the long, traditional, flowing beards of Russian men as a direct symbol of old-fashioned backwardness and Byzantine resistance to his secular, Europeanizing reforms. So, in 1698, he introduced the beard tax. If a man wished to keep his majestic traditional beard, he had to pay up a hefty annual fee based on his social status. Upon payment, he received a special copper token, engraved on the eagle on one side and the words, "The beard is a superfluous burden," on the other. This token was, effectively, a beard license that he was legally required to carry at all times, much like a modern driver's license. If a man was caught with an unlicensed beard, the police, the Tsar's shaving squads, would publicly and forcibly shave him on the spot, often brutally with dull instruments. It was a brutal, state-sponsored attack on the very concept of a majestic flowing beard, a war on traditional hipster aesthetics centuries ahead of its time. The law was an instrument of forced cultural change, demonstrating that to Peter, aesthetic conformity was as vital to modernization as a new navy. Number 10. The fork, satanic silverware. Today, the fork is an indispensable basic eating utensil. But in the 11th century, this simple piece of cutlery was seen as a scandalous, effeminate, and even blasphemous invention that threatened Christian morality. The crime: using an artificial, pointy implement to transfer food, thereby replacing God-given natural tools. The logic of idiocy. In a 10th century point, Byzantine princess brought a set of delicate golden forks to Italy for her wedding. The local clergy was horrified. The argument against it was profoundly theological. God had given humans 10 natural utensils, their fingers. To use an artificial pointy implement was seen as a direct insult to the divine design and an act of excessive soft luxury. One influential cleric even preached that the fork was a diabolical luxury and that using it was a sign of excessive pride and softness. The ultimate validation of this superstitious idiocy occurred when the princess later died from the plague. It was widely and publicly declared that her death was divine punishment for her unnatural, fork-using, excessively luxurious ways. It is a powerful, absurd reminder that one generation's essential, common tool is another's satanic, luxury implement, proving that resistance to new technology is not a modern phenomenon. If this marathon exposé on human stupidity made you question everything you thought you knew about history, and we bet it did, then prove it. Share this video with one person who still thinks they can sing in the bathtub and tell them the truth. To ensure you never miss a counter-narrative, hit that subscribe button right now. Don't just observe history, challenge it. We'll see you in the next investigation.